All right. Are we live yet? It looks like we are live.
We are live.
Excellent. We're going to start. Well, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 30th. We have 10 bills on the docket, and we are going to start off with the chairman of the Judiciary Committee with Delegate Clippinger. We'll start off with House Bill 31. We'll then go to Senate Bill 962, House Bill 26, House Bill 313, House Bill 523, House Bill 701, 870, 1000, 567, and 769. So with that, we'll kick it off to you, Mr. Chairman. Where are you? There you are with House Bill 31. The floor is yours.
Good afternoon. I'll try and keep it relatively brief, but thank you for hearing House Bill 31, legislation that would address, I believe, an imbalance in the fees that we charge for people who are filing summary ejectments, the first step in the eviction process. The bill would raise the amount for a summary ejectment from $15 to $75, $75 everywhere except Baltimore City, where it'd be $85. It's an extra $10 in Baltimore City that pays for the sheriff. The bill also increases the surcharge, the maximum authorized surcharge for civil fees from $55 to $85. And then in district court, it raises all other cases from $18 to $28. The bill does a couple things with the money that's raised from this. One of the things that the bill does is it addresses a shortfall in MLSC. The additional money that goes from circuit court case filings and from district court case filings would go to help fund MLSC and fund part of the gap that they have going into fiscal 22. As members of this committee well know, they have a gap largely because of a drop in the amount of money that's coming from escrow, interest on escrow accounts. And quite honestly, there have been fewer cases filed during the pandemic. This would raise about $3.3 million of the gap that they have, which is about $9 to $10 million for fiscal 22. The increase in the summary ejectment cost would go to two areas connected to our crisis and evictions in the state. Half of the money, half of the $60, so $30 would go to a right to counsel fund that the Judiciary Committee envisions would be run by MLSC. The money would pass through MLSC to other providers so that they can do the work of providing right to counsel. And then the other half would go to rental assistance, and that money would go to DHCD so that they could provide assistance for renters so that hopefully we could avoid the evictions in the first place going forward. I know that there is a considerable amount of money now, about $1.2 billion in stimulus money that's going to go into rental assistance. The idea here is to have that money for the long term, not for when that money runs out, so that we can continue to find ways to avoid evictions where we can. The bill, and I'll address one issue that I know that is of concern. Right now, landlords can pass on all 12 months of the fees that they charge, that they have to pay in summary ejectment. They can pass those on to the tenants. The bill, as it's coming over from the House, would say that the first 3 months cannot be passed on to the tenants. The remaining 9 months can be. However, that implies that the summary ejectment is being filed over and over and over and over and over again every month. The sense of the committee was that if somebody had stopped paying rent and continued not to pay rent, the summary ejectment would be filed once, not over and over again. So the idea here is that if somebody is constantly late paying their rent, but they ultimately pay it, that they should be somehow incentivized to pay their rent on time, as opposed to penalizing somebody who has just completely run out of the ability to pay rent altogether. Those people shouldn't be caught up in that and shouldn't be swept up with that. So with that, I think I went a little too long, but hopefully not too long. And I thank you very much, Mr. Chairman and committee, for hearing me out.
Excellent. Thank you for addressing the rental assistance fund. That was a part of the three pots of money that we were I think spinning our heads around because of the money that's coming in from the feds. You're, I think, almost 800 million, a little bit more than 100 million. So Really appreciate that. And we'll be in discussions very shortly because we've been kind of crafting our own
Sure.
side here, and we'll be in touch. So, Mr. Chairman, I have two witnesses here, one for your favorable with amendments and one unfavorable. So we'll go off to Mr. Hill first with the favorable panel. So, Mr. Hill, the floor is yours.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Again, my name is Matt Hill. I'm an attorney at the Public Justice Center, also representing today for Renters United Maryland. Renters United Maryland supports HB 31 with amendments. I won't repeat what Chairman Clippinger said, but the key policy here is to end the state subsidy for landlords filing eviction cases, and we strongly support that and the ending of serial eviction filings. The key amendment that Chairman Clippinger already mentioned is that the House Bill 31 was amended to allow the court or the landlord to pass on this increased surcharge after the first 3 surcharges assessed in a year. Renters United Maryland strongly opposes this amendment and opposes the bill if the provision is not struck. Allowing a fee pass-through, tenants who are struggling the most will face higher fees to avoid eviction and more instability, especially now in the middle of a pandemic with 200,000 families facing eviction. This is unconscionable. Tenants still have an incentive to pay the rent timely because landlords can still assess a 5% late fee and the court filing fee, just not the increased surcharge, in our opinion. If a landlord truly wants to evict a tenant who's chronically late, the landlord, after 3 judgments, can just foreclose on the right to redeem and cut off the pay and stay. There's no need for the landlord to continue seeking judgments and passing on the increased surcharge. Further, I understand the intent of the judiciary, I really do, but trying to enforce when a landlord is entitled to pass on the surcharge and when they're not, just as an attorney who's just looking at a cold ledger without anything else, is going to be extremely difficult, if not impossible. And so this kind of provision is almost impossible to enforce, in our opinion. Other differences between HB 31 and SB 530. SB 530 is the Attorney General bill that the JPR heard earlier. SB 530 would raise that surcharge to $120. We support the higher surcharge, assuming that there's no pass-through. We support, as an SB 530, extending the surcharge to all eviction actions, not just failure to pay rent, so landlords don't have an incentive to use other forms of eviction action to get around the surcharge. And then I appreciate also the chair's point about rental assistance. Yeah, we've calculated over $800 million coming in rental assistance from the feds. That money can be spent through 2025, as I understand it. And so in the near term, there is no need for additional rental assistance. Rental assistance is incredibly important, and we would urge the committee to come back and focus on that in later years. But right now, the allocation should be to MLSC and the Right to Counsel Fund. Thank you.
Excellent. Thank you, Mr. Hill. Yeah, we'll definitely have that discussion moving forward in the next couple of days here. So for and this, I'll ask this to the chairman, but you all did you added a charge in the circuit court as well, right? You had a charge circuit court, district court. I think you came to like $85 or something like that, and then circuit you went to not more than or not less than 25 or more than $25 or something. Hold on, let me get the chairman here. Sorry, there you go.
Yeah, so there's 2 parts to the increases. There's the increase to the summary ejectment charge to 75 and 85 in the city. But then, yes, we give change the maximum authorized surcharge for civil cases in circuit court from 55 to 85, and from civil cases filed in district court from 18 to 28. That money directly would go to MLSC to backfill the gap that they have. So that's the idea, is that money goes to that, and then the other monies go to the other 2 pots.
Got it. Thank you very much. All right, excellent. So then we'll now move on to the opposition panel, which is Mr. Enton. There you are. Floor is yours.
Thank you very much, Mr. Chairman. Members of the committee, Robert Enton, on behalf of the Maryland Multi-Housing Association. I've appeared many times before the committee this session, it seems, on their behalf. And they are the largest trade association of residential rental property owners in the Baltimore metropolitan area, also in Montgomery and other counties as well. Let me just say clearly and categorically, without any question whatsoever, no state in the country, no state in the country says that a landlord cannot recover their court cost when they file an eviction proceeding. No state, none, zero. None of our surrounding states and no other state in the country. I'd be happy to furnish the committee with the citations for our surrounding states to the Virginia Code, the Delaware Code, the Pennsylvania Code, the North Carolina Code, you name it. None of them do that. In fact, it is totally unprecedented under Maryland law that you would prohibit a party from recovering their court costs, either when the judge awards it. And that's typically, I've never been involved in any piece of litigation where the court didn't say, if you got a judgment, you got the amount of, X amount for your claim plus the court cost. And this is a committee of attorneys, and I think you'll bear that out. Or where if you're suing on a debt and the debtor pays it, you can't recover the court cost as part of the settlement. To me, it's just totally unprecedented. I would also point out that our filing fees today, it's not just the $15 that you pay. You also have to pay for the writ of restitution. That takes it up to $60. And now you're going to add another $70. You're going to be at $130. We'll have the second highest filing fees for an eviction amongst all of our surrounding states. The only place that's higher is DC, and that's because they have the U.S. Marshals serve the eviction papers. Maryland happens to be one of the only states in the country where the tenant gets these multiple bites of the apple. Now, it's interesting to me that public justice says they're opposed to the bill. If instead of getting 4 bites of the apple, you only get 3. Never to change that law. And that was one of the reasons the filing fee was set at $15 back in the 70s, was because when the tenant comes in to redeem, and that's what they do, 93% of the time they redeem. And they set it at, and I'll wrap up, Mr. Chairman, they set it at $15 so that the tenant wouldn't have to pay an excessive amount of court costs. I'll close by saying this, that the Attorney General was the one who came up with this notion about that, the landlords use the courts as collection agencies. There's no other business anywhere in the state of Maryland. If the buyer quits paying for the service, if the buyer doesn't pay for the goods, then the merchant must continue to furnish the service. We can't do that. Is we have to continue to repair the property. We have to continue to maintain the property. We have to continue to improve the property. If it's an apartment house, we continue to provide the heat. And our creditors don't stop going after us because the tenant hasn't paid the rent. So for all those reasons, Mr. Chairman, I'm repeating my testimony from the before. We strongly are opposed to the bill and that provision. Thank you. Thank you.
Thank you very much. All right. With that, that'll conclude the testimony for House Bill 31. I'll turn to the committee for questions. Seeing none, thank you very much, Mr. Chairman, and to the panelists. That concludes the hearing for House Bill 31. We'll now move on to Delegate Holmes. You're up with House Bill 313. Apologies for delay here. How are you, sir?
Wonderful, sir. How about yourself? Thank you so very much for having me here in reference to House Bill 313. House Bill 313 is a statewide reserve study bill. And as you can see by the fiscal note, this is the 3rd year that I have had this bill presented. Last year, I had 2 bills. One was a Prince George's County only bill. The other was a statewide bill. The statewide bill, I believe, ran out of time due to COVID. However, the Prince George's County bill did go through, and the reserve studies have been implemented in Prince George's County since last year. And if I could, Mr. Chair, I'd like to just read a small little quote from one of the stakeholders that reads as follows, relevant to the Prince George's County bill. It says, "Our managers have reported that the pushback they received at budget time on increasing assessments to fully fund reserve have vanished under this law. Our communities will soon be funded in order to meet future replacement and safety needs. We welcome this legislation. And that's just a quote from one of the stakeholders in this particular scenario. There has been some discussion about costs relevant to reserve studies, and I have reached out to professionals across the nation. Costs of reserve studies range in price from $500 to $10,000, with the typical cost of a reserve study, obviously depending upon the size of the community, ranging between $3,000 to $5,000. And I also would now take the opportunity, Mr. Chair, if I could, is to read a little statement from one of the reserve study specialists relevant to small associations. And he says here, these small associations can get either an inexpensive reserve study or get a reserve study company to simply give them a funding estimate with very little cost. The reserve studies are necessary, Mr. Chair, because without a reserve fund, the common ownership community owners, lot owners, and unit owners will be assessed a special assessment. And when those special assessments are due, it is mandatory that the unit owners and the lot owners pay those special assessments. Otherwise, they will lose their homes, which is why this special assessment, which is why this reserve study is so desperately needed. I'm hopeful that you received an amendment. I presented an amendment to the amendments office yesterday. The amendment is per request of another one of the stakeholders. And with the amendment basically says that for a homeowners association, that a reserve study is only going to be required if there are recreational amenities or private roads in the HOA. And with this amendment, Mr. Chair, with this amendment, Mr. Chair, I do believe that I have removed all opposition to this bill. And I'm hopefully that we can get a favorable report out of the committee this year, Mr. Chair. And with that, I will yield and take questions upon your request.
Excellent. Thank you very much. We're going to go to the, you have one panelist signed up in opposition. We'll go with Ms. Jones, and then we'll kick it over to Senator West who has a question. So Ms. Jones, you're up. Good to see you.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Harris Jones, and I'm here on behalf of the Community Association Institute Maryland Legislative Action Committee. CAI is a organization, it's a national organization, but on the Maryland side, it's made up of community managers, people that sit on HOA condo co-op boards, attorneys that work with HOAs and condos. And in this case, we actually have engineers that actually do reserve studies and have, and in each case, they are in opposition of the bill. As much as we love the sponsor, we think that he has great intentions with this bill. But the concern is that they don't believe that a bill such as this that will cause HOA condo co-ops to incur costs to have such studies done. It's kind of, it's not a one size fit all solution to what we understand to be an effort to make sure that there's funds available to fix problems and concerns with common areas within these associations. The problem is that, as the sponsor pointed out, the cost for a reserve study, depending on the size of the community, could range from $1,800. I'm looking at some notes right now, to $7,000 to $10,000. One could say $1,800 isn't a lot of money, but it's all based on what the condo HOA or co-op can afford. And if they can't, that would mean they have to increase their costs to those that live in these associations, which can cause problems. And I don't think this is a time period, especially right now in light of COVID and the problems that people have had with costs, to pass a bill that could, encourage additional fees on HOA, condo, and co-op residents. So with that, if there's any questions, I'll answer them. But again, we do believe that this is a bill, put in with great intentions to ensure that people are preparing for future costs in these associations, but we don't think that it's needed. Thank you.
All right, excellent. So we'll now go to, that completes the testimony for House Bill 313. We'll now switch over to the committee for questions, and Senator West, you're up.
Thank you, Mr. Chair. And it's always great to see Delegate Holmes on this side of the aisle. So I'm referring to generically as that big aisle between the two houses.
Understand.
So I'm reading the bill for the first time, and I listened to Ms. Harris-Jones, who I thought made some good points. So first of all, I'm trying to figure what the reserve study consists of. And as she suggested, they come in all shapes and sizes. I would think at the very least, a reserve study should report what expenses are expected to be needed. Let's just use the condominium or the others on the condominium for a certain number of years, and how much those improvements are going to cost. Isn't that correct?
That is correct, and that's what the reserve study does. That is correct.
Okay, there's not much of a description of what actually the reserve study is to consist of in here. So I'm assuming that's what it would consist of.
And you're exactly correct. That is exactly what a reserve study covers.
Okay, and then you actually, it's not your language, it's existing language in the law that says the board of directors of a condominium has the authority to increase the assessment levied to cover the reserve funding amount required. So what the reserve study would come in, and then the board of directors would say, okay, the study says in the next 5 years, we're going to need $800,000 to fix these problems. So we're going to increase the assessment of the owners of the condominium by $800,000, correct?
That is correct. But the other side of that coin, if I may, Senator West, is what is happening now, that $800,000 used in your example then gets specially assessed to those homeowners. And in some cases, particularly, I can name several cases in Prince George's County, for example, where, using your example, the $800,000 is now split up between the HOA owners, and they have to pay them within 6 months.
Right, but doesn't this permit the same thing to happen? That the money could be, this says the board of directors of a condominium has the authority to increase the assessment levied to cover the reserve funding amount required, et cetera. And that's what would happen. The board of directors would tell each of the owners of the condominium that you owe an extra so many dollars as your share of the $800,000 that we're going to need to spend to fix the problems with the common areas of the condominium.
That is correct, except that in my example, you would not have 6 months with which to pay that. You can spread that money in reserves over a period of time. Okay. Therefore, it would be less of a cost to that individual unit owner at a very narrow time frame, which is the reason for this reserve study.
Okay, frankly, I think the idea of a reserve sounds pretty good, but there is an alternative, and that is you face the problem of the need for fixing up when it occurs, and you go to a bank and you borrow the money, and then the owners of the condominium units would have to pay their share of the repayment of the, let's say, a 15-year mortgage or a 20-year mortgage, their share of that mortgage on a month-by-month basis during the period of the mortgage. Wouldn't that be an alternative way of paying for the repairs? It
would be an alternative, except that there are several HOAs and condominiums that don't have the wherewithal to get those loans. Therefore, that's why the reserve study is necessary, so that reserve study is in the budget for the common ownership communities.
Okay, and my last question is, as I read the bill, there's no requirement that the board of directors of the condominium, or I assume of the homeowners association, there's no requirement that they effectuate these assessments. They have the power to do it, but this bill does not require them to do it. Is that correct?
It does require.
It does require.
Yes, sir, it does.
So once the study comes in, this bill requires the board of directors of a condominium to levy such an assessment on the owners of the condominium units.
That is correct, Senator.
Okay, thank you.
Can I respond?
Sure.
Absolutely.
No, and when I look at, and I think at this point, my understanding is members of the committee have probably heard from upwards to 1,000 different people throughout Maryland that have looked at this bill and they have concerns with it. And if these community associations do not have the wherewithal to fund the problems that the reserve study points out, it just goes to the point that where would they, they could not possibly have the wherewithal to pay for the reserve studies. Instead, what we believe is that HOAs and condos and co-ops should instead have the ability on their own to consult with specialists that do reserve studies to get guidance as they see fit to decide when to do the study, and if they do the study based upon their ability to assess their residents, to make those required whatever needs to be fixed, or they need to start funding, putting money into their reserves for. But it has to be based upon each co-op, HOA, or condo association, based upon what means or what funding they have accessible to do this type of work.
Chair, if I may.
Yes. Okay.
And as Ms. Lisa Harris-Jones indicated, the bill specifically states that a reserve study specialist is the one that does the reserve study. And the reserve study specialist, and in the bill, I actually patterned the requirements for the reserve study specialist after the requirements that are required by CAI's reserve study specialists. So the ones that are preparing the reserve study are the same ones that get the designations from CAI, Mr. Chair. And again, the primary emphasis here is that if the common ownership communities do not have a reserve study, then the unit owners and the common owner and the lot owners are going to get assessed with these. And there have been foreclosures assessed against those persons because they have not paid the special assessment. And the reserve study is a method to circumvent that forced foreclosure, Mr. Chair. And it works everywhere that is being put in place. Thank you, Mr. Chair.
All right, excellent. Thank you very much. All right, and with that, seeing no further questions, that'll conclude the hearing for House Bill 313. We'll now move on to Delegate R with House Bill 523. Delegate, you are up. Welcome to Judicial Proceedings.
Thank you, Mr. Chairman, members. For the record, I'm Delia Attar, here presenting House Bill 523, repossession for failure to pay rents. This bill was filed as a local Baltimore City bill. In Baltimore City, landlords are required to register their rental properties. The bill required at trial that the landlord prove by a preponderance of the evidence that the property is registered. Last session, I filed it and I worked with advocates to ensure that there's no opposition, and the bill passed the House of Delegates unanimously. This session, I refiled the bill in the exact form as it passed last session unanimously. The bill did not have opposition at the time of filing. The House Judiciary Committee added multiple amendments. They combined two other bills, House Bill 524, which is a similar bill. It was actually mirrored off of my bill, but this one's for Anne Arundel and Prince George's counties, and House Bill 49, lead risk reduction compliance, and they made it a statewide bill. It's my understanding that now there are several parties that are concerned about this bill and they are requesting amendments. So I asked the committee to please read the testimony from all, including the city of Annapolis, I believe has some amendments. I would like to point out that Chief Judge Morrissey is asking for proof be presented at trial and not at the time of filing. And that's the way I drafted the original legislation that was filed this year after working with them. And I believe he's referring specifically to page 3, lines 29 to 33. That's the concern. And my understanding is it has to do with the clerks and how things are filed. And also MMHA is requesting the lead paint requirement be effective on the date the lead database is up and running. And as I noted earlier, I worked with all the parties to ensure my bill is filed in a way that satisfies all of them while reaching the same policy goals. I ask the committee to please consider their concerns, and I ask for a favorable report. Thank you.
Well, thank you very much, Delegate. So a lot of moving parts. It's obviously morphed from when you initially filed it. So as introduced, just a Baltimore City bill, is that right?
Yes.
So now 3 other jurisdictions, or now it's statewide.
Now it's statewide, and 2 bills were included in it. But yes, as I filed it, it was just for Baltimore City, and it was just requiring the registration.
Got it. So I've got your senator here. I'll ask the senator for a question, but we'll be in close touch as we work through, just because it seems like it got more complicated as we went on. But Senator Carter, floor is yours. Go ahead.
Thank you, Mr. Chair. I just wanted to say welcome to my delegate from the 41st District, Delegate Atai,
Thank you.
over here in the Senate. I move favorable. Thank you.
Thank you.
Senator's got your back. All right. Well, thank you very much. Looking to the committee for questions. Seeing none. Thank you very much, Delegate. And with that, that'll conclude the hearing for House Bill 523. We'll now kick back up to Delegate Lopez with House Bill 26. I see you're here. Delegate Lopez, welcome to JPR.
Thank you, Chair. And thank you, members of JPR. Good afternoon. For the record, I'm Delegate Leslie Lopez, and I'm asking for your support for House Bill 26. This bill bans the use of mass-produced documentation known as robo-signing by requiring that debt collectors show that private student loan debts are valid when attempting to collect. This bill passed favorably in ECM last year in nearly the same posture. It passed unanimously this year in appropriation, nearly unanimously in judiciary, and there is currently no opposition. Right now, for background, ad hoc trusts can purchase private student loan debts and then go to a Maryland courthouse with little more than an Excel sheet of names and then legally obtain wage garnishment on debts that are no longer owed. The pandemic has not stopped this exploitative practice. In fact, every member of this committee has had constituents involved in one of these unsubstantiated lawsuits last year. The National Collegiate Student Loan Trust, just one of these creditors, owned more than 15,000 loans owed by Maryland borrowers, totaling more than $190 million. The federal government has ordered this trust to pay over $20 million for its deceptive practices in the past. An analysis of court filings shows that this creditor alone has filed more than 1,300 cases against Marylanders in the past 5 years. More than half of these lawsuits are against borrowers in majority minority zip codes, including Montgomery and Prince George's counties and Baltimore cities. And 25.9% of all of these lawsuits analyzed were filed in Prince George's County, which, as the committee knows well, was the center of Maryland's foreclosure crisis a decade ago. I'd like to draw your attention to a chart that's in my written testimony. And here you will see the National Collegiate Student Loan Trust cases in your respective districts. Senators Carter, West, and Sidnor had more than 40 cases involving constituents. I had 53 in my own district, District 39. And please know that these are only the cases that we could confirm using zip codes, but there are likely more, and some may overlap into neighboring districts. Because more than 90% of private student loans require co-signers, parents and grandparents are frequently defaulting. According to AARP, 37% of all student loan borrowers over 65 are in default. So not only is the potential to retire put at risk, many of these seniors are on a fixed income and have benefits that are highly susceptible to wage garnishment in these unsubstantiated lawsuits. So to sum it up, borrowers only take out these private student loans as a last resort when their federal loan options are gone. They are among the most economically vulnerable students in higher education and have very few protections. Private student loan borrowers did not receive any federal COVID relief, making their financial situations even more dire this year. I urge you to support this bill and ensure that student borrowers in Maryland do not fall victim to predatory and unsubstantiated lawsuits.
All right, excellent. Okay, I look at question from Senator West.
Thank you, Mr. Chair. So I'm trying to figure, you're talking about predatory lawsuits. So the only lawsuit would be filed if the student or former student hasn't paid the educational loan in accordance with the terms of the loan, right? Why would that be a predatory lawsuit?
It's a predatory lawsuit because there's wage garnishments that far exceed what was owed. So a lot of times what we're seeing is the National Collegiate Loan Trust will have someone who at one time had defaulted, but had paid back the amount that was owed. But now they're coming back to say that this person still owes money, even though that they have paid off that debt. And because there's no requirement at the point of signing a wage garnishment to show the exact amount that's owed, this is actually a legal loophole.
I'm sorry, I'm still confused. If the person who extended the loan has been paid off, why would that person be filing another lawsuit or garnishment for a loan that's already been repaid?
Because these trusts understand that there's no requirement to prove the amount that's still owed, so they can continue to charge people who do not have the resources to hire representation.
Well, if that's the case, then why wouldn't you do a bill that would make it a crime to sue someone for money that's not owed? What this bill seems to do is to require whoever's filing the lawsuit to file copious amounts of paperwork with the court. Is your theory that the best way to stop these predatory lawsuits from being filed is to harass the people who are owed money by students?
Well, a couple of things. One is that the people who are servicing the loans are different than the lenders. It's a different group of folks, right? So what we're talking about are trusts, who are people who buy up debt that they think is going to be bad debt, that from people who are economically vulnerable. So it's not necessarily the lenders who are engaged in this. There's all sorts of restrictions.
But it could be the lenders.
Typically,
and the lenders are subject to the same requirement of filing all this paperwork as the servicing organizations, right?
no, it's typically not lenders who do these trusts.
But it could be.
The way the bill has been amended is that it's specific to trusts. Last year's version of the bill had a broader set of definitions, and it includes banks and credit unions. But we had a lot of discussions with the banks and credit unions, and they're really not the people who are undergoing this practice. And they would also have access to the numbers for the loan origination to begin with. So it's pretty easily define the people who are the bad actors in these situations. It's not typically the lenders. It's these ad hoc.
I'm trying to curtail the questioning because we get a lot of other bills. Let me just ask you one final question. Explain why this bill requires such copious amounts of paperwork to be filed with the court. For example, copies of all settlement communications made in the immediately preceding 12 months, redacted to withhold the student loan borrower's social security number. Why in the world would the court need to have copies of all settlement communications in the meeting? And assuming, I guess this assumes that these settlement communications have been in writing rather than orally over the telephone, right?
Yeah, I think there's certain regulations about how communications can be undertaken and what modalities. So I think these are letters, but it's important to show that people are told exactly how much money that they owe if they are to pay it. And it's important.
Sure, but why would you file all that with a court?
Well, if you're going to do a wage garnishment with a specific amount, then a specific amount that's owed needs to be mentioned.
Well, of course, that needs to be mentioned, but this requirement is that all copies of all settlement communications in the immediate preceding 12 months, that could be copious paperwork. I mean,
I would say that there's no opposition to this, and we definitely did our due diligence with the banks and the
some opposition in the Senate.
Sure, I haven't been informed of any opposition, but I mean, I would tell you that these are all very standard documents for processing loans. It's nothing outside of the norm of what's customary.
Okay, thank you very much.
Okay, thank you very much, Senator West. We'll go on to Senator Casserly.
Mr. Chairman, just really briefly, so I'm just trying to understand the bigger picture here. It sounds like these trusts or whatever, the debt collectors, they obtain a copy of a confessed judgment promissory note. Is that what they use? And then come in and confess judgment? Or what's the documentation, if that's not it, that's actually presented to the district court to allow them to get these garnishments?
From my understanding, they don't even need a promissory note. They need to have a list of the names and addresses of the people who owe them, and then from there, I mean, it's robo signing. It's a pretty It's a pretty quick process. So this bill is to require them to show those types of documentation. So it's clear exactly how much is owed. It's in everyone's best interest for people to pay what they owe, but not be exploited into paying more because they can't afford legal representation to fight back in these lawsuits.
Maybe if anybody else is out there, they can explain to me later. I don't understand how you can get a wage garnishment without either having a confessed judgment or a regular judgment to verify the debt. So
yeah, I mean, that's exactly the problem, but I can certainly have other folks reach out to you.
I just don't know that I'm able to go in the district court and say, here's a list of people how much you garnish their wages. I normally have to go in with a lot more information. That I have to have something other than just to say I'm going to start putting wage garnishments out. But okay, thank you. Thanks, Mr. Chairman.
All right, thank you, Senator Castley. All right, seeing no further questions, thank you, Delegate Lopez. And with that, that'll conclude the hearing for House Bill 26. We'll now move on to House Bill 870 with Delegate Hill. Good to see you. You're up. How are you? I'm going to ask to unmute you, Delegate Hill. And there you go.
Hi, Mr. Chairman. It's good to be here. Mr. Vice Chair and committee members, can you all hear me?
We can.
Can you hear me?
Yes, we can. Loud and clear. Your video is a little
okay,
loud.
fine. All right. So House Bill 870 is legislation that we have worked out of the request of Attorney General Brian Frosch's Access to Justice Task Force Life and Health Planning's Committee request, and we worked it out with the Elder Law and Estates and Trust sections. And what we're trying to do with this is to create an option within the limited and general power of attorney short forms to allow for a person to be able to assign an agent who can help them to complete government forms for assistance with Medicare planning. So that's what's been missing. You all are probably familiar that the POAs do allow for certain kinds of assignments to help with financial matters and some other issues. And what we found, particularly during COVID, is that when people were hospitalized, particularly in some other situations as well, they could not assign an agent to act on their behalf for Medicaid planning. And that's a really big deal. So, I mean, it's really pretty simple. So we're allowing them to assign, and they can assign the agent and specify which powers they want the agent to have. They can assign, under this bill, access to financial, medical, and other supporting documentation, which Medicaid and other government programs require. They can hire a Medicaid planner, which can be very, very important. And they can also avoid potentially expensive and lengthy guardianship process to get these things done. And should they become incapacitated, this becomes really critically important. There have been concerns that the form needs to be done in a way that vulnerable people can't be taken advantage of, so that they're aware if they're saying, yes, you can spin down my assets in order for me to apply for Medicaid, or I'm, that can be done in a way that they're safe, in the parties involved from the Maryland Bar and the other advocates feel that what's before you, which was amended from the initial bill and then passed out of the Judiciary Committee and the floor, is a form that will protect folks from being exploited, make sure they're well informed about what their options are, and yet give them this authority, which is so very much needed.
All right, excellent. Thank you very much, Delegate Hill. Seeing no questions from the committee, that'll conclude the hearing for House Bill 870. Thank you very much. Good to see you. Have a great afternoon.
Thank you.
All right. Now we'll move on to Delegate
hopeful
Mccomas.
favorable report. Be blessed, guys.
Excellent. Thank you. All right. Next we'll move on to Delegate Mccomas. Are you still here with us? I see you're logged in, but there you are. I'll ask to unmute you. We'll go with Delegate Mccomas with House Bill 701. The floor
Thank
is
you.
yours.
Thank you, Chairman Smith. This bill's been before JPR for several years. Initially in 2018, it was HB 600 and it passed the House as amended, and then there were no further actions in JPR. HB 1252 was passed in 2019 and received a hearing, but no further action in JPR. HB 820 received a hearing in the House, but no action last year because it was a victim of COVID. So it didn't get any vote in the House and never made it over to the Senate. I'm hoping that this is the third time and it's the charm with JPR. Just saying and hoping. 701 passed the House unanimously this year. Given all of the current stressors and requirements to stay inside, there's never been a really greater need for child abuse and neglect training. Resources for such training and the conduit for the information remains a cornerstone in the detection and prevention of child abuse. Training on how to recognize and report child abuse will expose the monsters like Dr. Nassar, who thrive in an atmosphere of misinformation and ignorance, and enable them to operate with slight chances of detection. It was never clear that training is imperative, as many of Dr. Nassar's horrific acts of abuse took place when the children's parents were actually sitting in the examining room. The support of this bill has MCCASA, the Coalition to Protect Maryland's Children, the Mid-Atlantic Panda Coalition, which is the dental and dental technician group, LifeBridge Health Group, their Center for Hope, which is the Baltimore City Child Abuse Center aligned with LifeBridge, and also the Maryland Psychological Association. Certainly, if you feel any needs to make any amendments to the bill, I'm always open to that. This is not I know it's not my bill anymore, and now it's the Senate's bill. So with that, I thank you very much for allowing me to testify.
Excellent. Thank you, Delegate Mccomas. Always good to see you, and we'll look at this bill very quickly this time around. So you'll definitely make sure you had a consideration earlier on. All right, looking to the committee, questions, seeing none. And with that, that'll conclude the hearing for House Bill 701. Thank you very much. Good to see you.
Thank you.
All right, now we'll go on to Delegate Pippi with House Bill 1000. Good to see you. Welcome.
Thank you. Good to see you too. Chairman Smith, Vice Chair Wallstreicher, and members of the Judicial Proceedings Committee. Delegate Jesse Pippi for the record, here to testify on House Bill 1000. This bill deals with court-appointed guardians for minors and disabled persons. Currently, under Maryland law, a court-appointed attorney for a minor or disabled person may, without court authorization, pay or apply income and principal from the estate as needed for the clothing, support, care, protection, welfare, and education of the minor. A guardian of a disabled person may, without court authorization or confirmation, pay or apply income and principal from the estate as needed for the clothing, support, care, protection, welfare, and rehabilitation of the disabled person. Income and principal may also be paid or applied without court authorization or confirmation for the benefit of persons legally dependent upon the minor or disabled person. What this bill says is that a guardian who is not a family member may not distribute or disperse property without court authorization or confirmation if the distribution or disbursement would financially benefit the guardian or the guardian's family. Let me explain. If the guardian needed to sell the home of the disabled person, maybe they use their wife as the realtor, and then they give their wife a 10% commission to do so. Or another example, the guardian needs to hire a cleaning service for the disabled person, and they get their brother-in-law to do the job and give them $10,000 to do it. Matter of fact, there's actually a Netflix documentary or a TV show that just came out called I Care a Lot with Rosamund Pike. And it's literally about a legal guardian who drains the money from clients by selling their assets. We had a situation in one of our jurisdictions in Maryland where you had a court-appointed attorney that hired his own spouse's company to basically drain the funds out of this guardian or this estate. So what this does, it closes just kind of a loophole that we have. Right now, a court-appointed guardian has to get permission for certain things. This would just require them to make sure that they get permission from the court before they can do anything that would benefit themselves financially. Obviously, I entertain any questions, and I would love to get a favorable from the committee. Thank you, Mr. Chair.
Excellent. Thank you very much. Looking to the committee for questions, seeing none. That'll conclude the hearing for House Bill 1000. Thank you very much. Good to see you, Delegate, and have a great afternoon. We'll see you
Thank
soon. All right. We have two more bills left on the docket. These are Montgomery County delegation bills, and I'm told that Senator Lee will be presenting. So Senator Lee, who is absent from the room at the present time. Here you go. Senator Lee, there you are. Senator Lee, we've got you down for House Bill 567 and House Bill 769.
Okay, yes, correct. I'm standing in for Senator Zucker. These are the Montgomery County bills, is that correct, Mr. Chair? Okay, just a minute.
That's correct, yes. And then we have one panelist sign up in opposition with Ms. Jones is here. All right, Senator Lee, I think you're on. Let me unmute you here.
Okay, I think we can do 567 first. As amended, this bill requires that the governing body of a cooperative housing corporation, condominium, or homeowners association established in Montgomery County on or after October 2021 update their reserve study every 5 years following the completion of the initial reserve study. For cooperative housing corporations, condos, or HOAs established before October 1st, 2021, if a reserve study was last completed on or after October 1st, 2017, then the governing body must update it every 5 years. And if a reserve study was last completed before October 1st, 2017, then the governing body must conduct a new reserve study before October 1st, 2022, and then update it every 5 years. Also, the governing board of a cooperative housing corporation, condominium, or HOA in Montgomery County must provide funds to the reserve in accordance with the most recent reserve study, and for HOAs may increase an assessment levy to cover the reserve funding amount, notwithstanding any provision restricting assessment increases or capping assessment that may be levied in a fiscal year. On the House floor, the vote, it passed a House 122 to 13. House delegation vote was 23-1, and the Senate delegation vote was 7-0. We'd like to move favorable to this bill.
So thank you, Senator Lee. So with that, that'll conclude the testimony for the proponents. We have one person signed up in opposition. So Ms. Harris-Jones.
Okay. The bill is the exact same bill as House Bill 313, but from Montgomery County. So my arguments remain the same. I just want to point out that, again, I think you've heard from about 1,000 constituents throughout Maryland, a lot of which came from Montgomery County that are in opposition of this bill. So again, I'm here on behalf of the Community Association Institute, Maryland Action Committee, in opposition of House Bill 567.
Okay, excellent. Thank you very much. All right, and with that, that'll conclude the hearing for House Bill 567. We'll now move on to Senator Lee with House Bill 769. And Senator Lee, let me unmute you again.
Again, thank you, Mr. Chair. This bill was amended in the House. Delegation amendments were folded into the bill before it was formally introduced. As amended, the bill just provides that a committee of the Housing Opportunities Commission of Montgomery County is a public body for purposes of the Open Meetings Act. That's all the bill does. And on the House floor, the vote was 134-4. The House delegation vote was unanimous. Senate delegation vote for Montgomery County was unanimous too. We love to have the committee move favorably on this bill.
Okay, excellent. And with that, that'll conclude the hearing for House Bill 769. We'll now move on to our final bill of the day with Senator Jackson, Senate Bill 962. Senator Jackson, you're up.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Senator Michael Jackson, representing District 27 on behalf of Senate Bill 962. Cassidy's Law. Senate Bill 962 is a very straightforward bill that simply requires homeowners to maintain homeowners insurance after their mortgages are paid off. The bill would require owners of a residential real property to maintain homeowners insurance with liability coverage of at least $100,000 for bodily or personal injury occurring on their property after the mortgages are paid off. This legislation comes about from a horrific incident in my district, one of my constituents. A young lady, Cassidy Tucker, was mauled by a dog while in the yard of a neighbor. And the neighbors do not have insurance because their mortgage is paid off. Because of this incident, Miss Cassidy faces a myriad of surgeries and medical bills that are not covered because the homeowner did not carry homeowner's insurance with liability coverage that typical homeowners carry with an active mortgage. In addition to dealing with the trauma of the situation, Cassidy now faces plastic surgery and other related costs that are the responsibility of her family due to this, the party not being able to pay without the insurance. To attain recourse, the family of the young lady have been forced to do so through the legal system, as opposed to seeking it through an insurance carrier. A lien has been placed on the home of the homeowner, and now both parties are facing monetary hardships that simple insurance coverage could have covered. Requiring homeowners to carry insurance with liability coverage for mortgages that are paid off will provide a needed level of protection to both homeowners and those who are victims of unfortunate incidents, such as the one endured by Ms. Cassidy Tucker. I appreciate this opportunity to bring forward this legislation at this late date, Mr. Chair, and I do apologize for that, but this horrific incident is worth bringing this issue forward. With that, Mr. Chair, I would ask you and the committee for a favorable report on this bill, and I'd be happy to try to answer any questions that you may have. Thank you.
Thank you, Senator Jackson. And seeing no questions from the committee, that'll end the hearing for Senate Bill 962 and our hearings for the day. All right, so now we've got a voting session. Let's call it 2:30 down in the hearing room. It's gonna be about a half an hour break in between. So 2:30 down in the hearing room for a voting session. See you all soon.